Thank you, Andrei, for this, and the organizers for this very kind invitation. Well,
perfect time, no problem.
Let's see if I can deal with this. Well, my task is to give you an overview on the implementation in Italy of the directive. Of course, let's see if it's... Which one? Yeah. Okay, in Italy, the implementation was affected by this legislative decree of January 7, 2016, number 2, which means that it was one of the first, the second, decree that was adopted in the year. Probably the government was just a bit late on the deadline that was determined by the directive. I would have nothing to say specifically as to the, let's say, due care or due diligence, depending on which expression you prefer, of the Italian legislator as to the correct implementation of the directive. Actually, the task was to amend our special law, which is the Codes of Cultural and Landscape Heritage of 2004, that that is amended by this new law provision. By the way, the code was already embodying the past implementation law of the directive, as well as to the laws of implementation of the most relevant international conventions, such as UNESCO 1970 or UNIDROIT 1995. But here, well, just very, very quickly, what the legislator did with this decree was to amend some of the provisions of the code, namely Article 75, as to the definition of the scope of application of restitution. And I won't go into detail because, as I was saying before, they were very clever. They respected exactly what was the content of the directive. But on the other hand, it would have been difficult to, even though if we'll see that some errors can be made in implementing international conventions. Article 76 deals with the shifting of term in to the assistance 6 months, as was mentioned before. Article 77, action for restitution, the lapse of time limit. Here you have an error. Compensation is dealt with under Article 79. Obviously, it was not the same. And here it's interesting because in this part of the article, again, the conditions set forth by Article 10 of the directive are perfectly reported. So, and particularly the mention is made to due diligence and due diligence and due care. Well, what is new now that we have a perfect compliance with the definition of the cultural object as of Article 2.1 of the directive in the new law, and particularly also the other effect is the elimination of the annex, which brings to a broader scope of application of the protective legislation, of course, as has been already mentioned many times today. Well, of course, this has brought about an extension of the scope of application of the relevant Italian protection regime, and particularly from now on, with the implementation of the directive, also items of paleontological, numismatic, scientific interest, and items not belonging to collections listed in inventories or museums, archives or libraries or ecclesiastical institutions are also taken into account by the scope of application of the law and of the directive. But I would add that all this must comply with something that was evocated in the debate before. And from this point of view, the recital number 10 of the directive is really, really welcome, because it reminds everybody the existence of this Article 36 of the treaty. And actually, this is as you probably all remember, the contents of this article. What do the provisions of Article 34 and 35 talk about? They refer, as you may know, to the prohibition of quantitative restrictions on import and export and all measures having equivalent effect that are prohibited under EU law. And of course, Article 36 is the only exception rule. It's a derogation rule to the application of these general principles, I would say. Don't forget that these provisions were provisions having direct effect into not only immediately applicable, but they have direct effect, which means that they are part of these EU provisions that may confer rights and obligations to individuals, which the courts of member states are bound to recognize and enforce. So the point is that Article 36, if I may quote, states that the provision of the Article 34 and 35 shall not preclude prohibitions or restriction or justified by inter alia the protection of national treasures possessing artistic, historic, or archaeological value. Well, this is the English text, but we have a problem of interpretation. In this case, we are before a multilingual treaty, right? So from the point of view of international law, and having all the languages are equal from the point of view of the effectiveness and the legal validity. The point is that this text, mentioning the notion of national treasure, which, by the way, is the same notion utilized by the English version of the directive, is the same notion that you have in the French text, more or less the same as in the German text. If you look at the Italian, Spanish, and Portuguese text, you have a slightly different notion. They are not mentioning the word treasures, but more or less, if I can say it roughly, the translation is the protection of of items belonging to the national heritage. You see? Well, the point is, how can we get through this pitfall, of course? We have two different sides, if you want, of interpretation, and I would say that normally the Vienna Convention has, on the interpretation of treaties, has a specific rule, which is Article 33, which refers, in cases like this one, to the main importance of the object and purpose of the treaty. And let's say that the case law of the European Court of Justice is absolutely complying with this kind of an interpretation. So we should look at this article in considering also the purpose of the treaty, the object of the treaty. This article is coming after Article 34 and 35, of course, which means that the general rules are to be found in those articles. We are talking about rules aimed at implementing the internal market that was evocated also today. So I would say that the purpose and the object of the treaty, in a minute, if I can use it, is correspond to the scope of application of these two articles, and therefore Article 36 should be interpreted in a narrow sense as a derogation rule, as it is, if compared to the general principle that we find in the preceding articles. But we have to add that this is an open problem, because there is no case law on this specific point, which by the European Court of Justice, which means that nobody ever brought this problem to the attention of the court, a problem which may have some concrete different effects. Now, let's skip to another point, which is the connection with UNIDROIT that have been already mentioned very well by Marina Schneider before. Let's say that now, as it is clear, the recast of the directive, let's say that it's much closer to UNIDROIT than the former directive 93/7, and more or less there was a kind of an overlapping between the two texts. Again, today, only the state can sue the possessor of the holder for the return proceeding. It's Article 6, not 69. And the ownership of cultural objects shall be governed by the law of the requesting state. These are the two main points that still remain in the directive if compared to the UNIDROIT example. And this last one is particularly, I would say, compulsory result of the existence of Article 345 of the Treaty on the Functioning of the European Union, according to which the treaty shall in no way prejudice the rules in member states governing the system of property ownership. And that's why it's up to the legislation of each member state to govern the problem of ownership. Now, there is a problem of implementation not particularly concerning the directive, but as in general as to the problem of restitution of cultural property. Again, our Code of Cultural and Landscape Heritage, in its Article 87, makes a referral to the UNIDROIT Convention. Let me just quote the text of this article. It's under the section concerning the restitution and UNIDROIT Convention, and this rule stresses the fact that the restitution of cultural properties is governed by the provisions of the UNIDROIT Convention and the related laws of ratification and enforcement. So it refers directly to the Italian law of implementation. But, well, this is the law of implementation, Law 213 of 1999, and its Article 3 expressly referring to the action for restitution, and as far as the problem of compensation is concerned, clearly states something which sounds a bit odd to our ears, because if you look, here is a problem of the possessor who must in any case give back the item he's got, but in case he can demonstrate and can give evidence of his due care or due diligence, he may obtain a fair and equitable compensation. But look what is the text of the implementation of UNIDROIT in Italy. It says that the purchaser must give evidence of acting in good faith. Now, Sophie Vigneron has explained very, very well what good faith is in continental law systems. Our Article 1153 is absolutely, more or less the same as 2247 of the French Civil Code, which means that good faith, as to the good faith at least. And in fact, possession is a French institute brought by Napoleon in order to facilitate the circulation of goods. That's why the Italian code took as an example the 8004 French codes, civil code, and that's why we have this important definition of good faith, which is not defined, by the way, but which is normally completed by the case law, the jurisprudence. So let's say that basically good faith is slightly, but maybe importantly, different from the concept of due care or due diligence. And it is true that according to the Italian jurisprudence, there's a famous decision by the Court of Cassation concerning a painting by the Chirico, where the problem was exactly the point that the owner, the possessor, which becomes the owner under Italian law, as in the French law, the point was he or not in good faith? Well, according to the court, when a professional is the possessor and the purchaser of a work of art, let's say that good faith is something very, very close to the evidence of due diligence, but it is not the same thing. So, in my view, this is a problem that should be solved, and that maybe should have been solved along with the implementation law to the directive, considering that we are talking about the same kind of problems. And in fact, what I can say is that in Italy you have not just one regime, legal regime for as far as the return proceedings are concerned, and then actually even after the entry into force in 2004 of the Code of Cultural and Landscape Heritage and relevant amendments, including the legislative decree implementing the directive, we don't have a uniform procedure for restitution and return for cultural property. And last but not least, I would add just conclusively, a last point for probably the discussion, if you want. This is an interesting point that has been an interesting article. As you see, it's a 64 bis, which means that it's been added afterward. It's an amendment of 2008 to our Code of Culture. And if you look at this very important statement, it says that as to the regime of international circulation, and I stress international circulation, the objects of the cultural heritage are not assimilated to goods. What does it mean? It's an important statement that I may share in principle. I would say not from a legal point of view, but in principle I do. I mean, when we talk about cultural heritage or cultural treasures, I could agree with the fact that it's difficult to consider them as a pen or whatever other kind of goods. But I think that this addition was made on purpose with a view to avoiding, possibly, the application of the European Union law concerning the circulation of cultural property. And again, we come back to Article 36. And again, the recital number 10 of the directive, I say it is welcome because it makes it clear that the notion of national treasure should be read within the meaning of Article 36. By the way, no notion of cultural treasure do exist under Italian law. We have a very, very broad definition in the code of what cultural property is, which is a very, very long list, which I don't want to mention because we don't have time. Let's say that the only limit is a time factor, which is that any item of historical, artistical, pathological, bibliographical, and whatever importance, that having more than 100 years is a cultural property. But we don't have any definition of treasure. And you see why, because our legislator, I have the impression that he or she or whatever, or they don't like, because it's an entity, they don't like the idea of identifying something with treasure, which is something more exclusive than referring to a general cultural heritage. If I make an example that it's really, you will pardon me, but if you think about the sleeping dress of Garibaldi, who is our national hero, if any, I don't know if there is, it does exist, but it is possibly an item which belongs to our national heritage. I would doubt that we could classify it among the national treasures, because in my view, a treasure is something different. It's a kind of an elite among a larger category of goods. So this is interesting because what's the meaning of this? What's the concrete effect of this statement? I personally doubt that it may have some very important and concrete effect, because in this case we have a ruling of the European Court of Justice, which is a case of long ago. It's a decision of 1968 that was concerning a commission against Italy. It was an infringement procedure because Italy at the time had the taxation on the exportation of cultural property amounting from 8 to 30%, and it was considered to be contrary to the EU provision, as it could discriminate in an internal market. So what the Commission was saying was, well, you can keep the taxation for the third countries, but you cannot keep the taxation inside the European Union. And actually, the Court of Justice found that the Commission was right, but particularly in that decision you find this very important statement, which is that according to the Court of Justice, cultural objects are to be considered as goods under the treaty as long as they can be, on an abstract dimension, if you want, be evaluated from an economic point of view. So I doubt that if actually the problem of the implementation of this definition of Article 64 bis could come before the Court of Justice. But I would be curious, because it would be a very interesting point to be raised before the court. So I leave you with this very famous portrait by Bangkok, which doesn't exist anymore because it was bombed during World War II. And I thank you for your attention.
Thank you very much.